Imagine gathering with fellow citizens to voice your opinion, to stand up for a cause you deeply believe in. This powerful expression of collective voice is a cornerstone of our democracy and a fundamental way for individuals to participate in public discourse. But when we consider the vibrant history of American protest, a crucial question arises regarding its legal boundaries. No, the First Amendment does not protect all types of protests without limitation. While it broadly safeguards the right to assemble and express views, these protections are not absolute. The scope of this right is defined by certain boundaries set to balance individual freedoms with public order and safety, ensuring that dissent can thrive without creating chaos or endangering others. The core mechanism behind these protections rests on the idea of expressive conduct. The First Amendment protects not only what you say, often called pure speech, but also symbolic speech, which is conduct intended to convey a particular message. Think of wearing an armband to protest a war or kneeling during the national anthem. Both are forms of expression. However, when speech takes the form of conduct, it becomes subject to greater regulation. The government cannot restrict the content of your message, meaning what you are trying to say. But it can impose reasonable time, place, and manner restrictions on protests. These restrictions must be content neutral, meaning they apply to everyone regardless of their message. They must also be narrowly tailored to serve a significant government interest, such as public safety or traffic flow, and leave open ample alternative channels for communication. To navigate these protections effectively, it is essential to understand where you are protesting. Protests on public property, particularly traditional public forums like parks and sidewalks, receive the strongest First Amendment protection. However, even in these spaces, governments can require permits for large gatherings to manage logistics and ensure safety. Protesting on private property, without the owner's permission, generally offers no First Amendment protection and can lead to charges like trespassing. Additionally, actions that involve violence, property destruction, or incitement to riot are never protected, regardless of the message they convey. These actions cross a line from protected expression into unlawful conduct. Understanding the difference between content-based and content-neutral regulations is key. A content-based restriction would be saying you cannot protest about climate change. A content-neutral restriction would be saying you cannot block the main street during rush hour, regardless of whether you are protesting climate change, a political policy, or a sports team victory. The concept of a designated public forum, like a school auditorium made available for community events, also highlights that while these spaces can be opened for expressive activity, they might have more specific rules than a traditional park. So, while your right to protest is robust and fundamental, it comes with responsibilities and clear limitations designed to preserve both individual liberty and societal order. By understanding the distinction between protected speech and unprotected conduct, and by recognizing the legitimate boundaries set by content-neutral time, place, and manner restrictions, you can ensure your powerful message is heard effectively and legally. This knowledge empowers you to engage in civic action confidently, knowing your rights and the parameters within which they operate.